I want to read you something. It is a real sentence that appears in real new construction purchase contracts across the United States right now, and I want you to pay attention to every single word. By signing this agreement, buyer waives the right to a trial by jury and agrees that any and all disputes arising out of or related to this contract, the construction of the home, or the condition of the property shall be resolved exclusively through binding arbitration. That sentence, or something very close to it, is sitting in the purchase agreement that hundreds of thousands of American homebuyers sign every single year. Most of them blow right past it. I would have blown past it too, honestly. You are sitting at a closing table with a stack of documents 6 inches thick, and someone is handing you a pen and pointing at signature lines. Nobody reads paragraph 31. That is exactly what the builder is counting on. Today on Built Wrong, we are talking about the clause that makes every other problem we have covered on this channel. The piece rate labor, the 15-year houses, the inspection theater, the model home scam, significantly harder to fight. This is the clause that takes away your right to sue before you ever move in. And once you understand how it works, you will never look at a builder contract the same way again. Here is binding arbitration in plain English. When you sign a new construction purchase contract with a volume builder, you are almost certainly signing a mandatory arbitration clause. What that means is that if something goes wrong, the foundation cracks, the roof leaks, the plumbing fails inside a wall, you cannot sue the builder in court. You cannot stand in front of a jury of your neighbors and tell them what happened to your family. You cannot join a class action lawsuit, even if 100 other buyers in your exact subdivision have the exact same defect from the exact same builder. Instead, you take your claim to a private arbitrator, not a judge, not a government employee, a private individual, often selected from a list that the builder has pre-approved. The proceeding is confidential. There is no public record of the outcome, and the arbitrator's decision is almost always final. There is no meaningful right of appeal. You get one shot in a private room with a decision maker the builder helped pick, and whatever they decide is what you live with. I want to be direct about something here. After everything we have covered on this channel, I think this is the single most important video we have made, because the piece rate labor and the bad OSB and the fake model home, those are problems you might be able to catch if you know what to look for. This clause is the thing that makes sure that even if you catch them, you have almost no power to do anything about it. The National Association of Home Builders openly advocates for mandatory arbitration in residential construction contracts. Their own published position is that arbitration is faster and cheaper than litigation. And they are right, it is faster and cheaper. For the builder, for the homeowner sitting on a $40,000 foundation problem with a $400,000 mortgage, fast and cheap is not what they are looking for. And the research backs that up. The Consumer Financial Protection Bureau, the federal agency created specifically to protect consumers in financial transactions, studied mandatory arbitration and published their findings in a report to Congress. The numbers are stark. When companies with arbitration clauses were sued in class actions, they invoked the arbitration clause to block those class actions 65% of the time. 65%. And the number of individual consumers who actually pursued arbitration claims was a tiny fraction of the number who were harmed, because the process is expensive, opaque, and designed to discourage you from starting. Here is the part that genuinely makes my jaw drop every time I think about it. The Dodd-Frank Act, federal law, passed in 2010, specifically prohibits mandatory arbitration clauses in mortgage contracts. Congress looked at this and said, when it comes to the loan you use to buy a house, you cannot be forced into arbitration. That protection exists. It is federal law. It covers your mortgage. It does not cover your purchase contract with the builder. So the loan that pays for the house is federally protected from forced arbitration. The contract that determines what the house is actually built out of is not. I am not a lawyer, and this is not legal advice, but I will tell you this: that gap did not happen by accident. It is the result of sustained lobbying by the home building industry to keep their construction contracts outside the reach of the same consumer protection laws that govern the financial industry. They succeeded. Now here is something that almost nobody knows, and that a lot of you who wrote in after the inspection video really need to hear, because several of you asked what happens if you already bought and something went wrong. In many states, including Texas, arbitration clauses in residential construction contracts are enforceable not just against the original buyer, but against subsequent purchasers. Published legal analysis from Texas construction attorneys confirms this directly. A subsequent buyer can be bound to the original construction contract's arbitration clause, even if they never signed it themselves. If you bought a 3-year-old new construction home from the family who bought it new, the original builder's arbitration clause may still apply to you. You inherited it with the deed. Before I get to what you can actually do about all of this, a lot of you have been asking for a practical tool that covers this stuff in one place, and that is exactly what we built. The Home Buyer's Audit Guide in the description has a full contract red flag section that covers the arbitration clause specifically, what the language looks like, what to ask your builder to remove, and what a modified clause looks like. If you are in the middle of a purchase right now, that section alone is worth more than the price of the guide. Link is in the description. Now, what can you actually do? The first move is to negotiate before you sign. Builders will tell you the contract is standard and non-negotiable. That is not always true, especially in markets where inventory is sitting. A real estate attorney reviewing your contract before signing, not after, can identify the arbitration clause and attempt to have it removed or limited. That review costs a few $100s. An arbitration proceeding on a major defect claim can cost you thousands in filing fees and arbitrator costs before you even get to the substance of your case. The second move is to know your state. California courts have found certain builder arbitration clauses unconscionable, meaning so one-sided they violate basic legal fairness, and refuse to enforce them. The South Carolina Supreme Court has struck down home builder arbitration clauses on the same grounds in documented appellate decisions. The law varies significantly by state, and it is actively changing. What you can do depends heavily on where you live, which is another reason why talking to a local attorney before you sign is not optional. It is essential. The third move is to document everything regardless. Arbitration is still a legal proceeding. Photographs, inspection reports, written communications, and repair estimates are still evidence. If you end up in arbitration, the quality of your documentation is the difference between a claim that goes nowhere and one that gets taken seriously. Here is the picture I want you to walk away with. Every investigation we have done on Built Wrong connects to the same system. The piece rate labor creates the defects. The fast growth lumber and the OSB accelerate them. The inspection theater keeps them hidden until after closing. The model home gets you emotionally committed before you ever read the contract. And the arbitration clause makes sure that when you finally figure out what happened to your house, your options for fighting back have already been quietly removed. This is not a series of unrelated industry problems. It is a pipeline, and the arbitration clause is the last lock on the door. The builders have lawyers who wrote every line of that contract. you are allowed to have one too. And in the meantime, the contract red flag section of our audit guide is the fastest way to understand what you are looking at before anyone hands you a pen. That is linked in the description below. Next time we are going inside the warranty, specifically how the 1-2-10 structure is engineered so that the most expensive defects in your home surface right after your coverage expires. If the arbitration clause is the lock on the door, the warranty is the countdown clock on the wall. Do not miss that one.